17, school is underway. Has your child complained of another child picking on him or her? 44 states have anti-bullying laws, including Florida. And around the country, there have been lawsuits against school districts about bullying. So how do you know, as a parent, when it's a case of kids just being kids or something serious and maybe you want to get an attorney involved? For your child's protection this morning, attorney Eddie Farah has been looking into the bullying lawsuits and is joining us now with a look at this. Good morning.
Good morning.
Unfortunately, this is a growing trend, or perhaps, Eddie, just more people are paying attention to bullying.
Yeah, there are a number of lawsuits being filed. Just this year, there have been just more than ever in terms of claims against school districts for allowing children to be bullied.
Is that right? And what are they basing it on?
Well, there was a recent case just settled in Pittsburgh within the last couple of months by the mother of a 15-year-old, a sixth grader, who was harassed because of her weight. She was called fat and she was tormented. Her mother filed a civil rights action against the school district based on sexual harassment, and that case was settled.
And it was settled out of court?
It was settled out of court, and Florida has an anti-bullying statute, as you know, that was passed a couple of years ago. 44 states have anti-bullying statutes.
Okay,
and,
so when you say anti-bullying law, what does it encompass? Does it encompass online threats? Does it encompass bodily threats?
Cyberbullying is considered, if you read the Florida statute as an example, was prohibited. Even if you're home using the school's internet network to cyberbully someone, you can be disciplined for that. Public humiliation, teasing, spreading rumors, encouraging other students to exclude or reject a student is a violation of the bullying statute.
Now, these kind of sound, I don't know, like tenuous arguments for the plaintiff. Do you have to have, as a parent and as a child, proof of this to present? And obviously, you probably don't want to go to court right away. Well,
you have to prove that the school knew or should have known that this was going on. And
that's tough to prove, isn't it?
Well, I mean, if maybe a teacher saw somebody being publicly humiliated and didn't follow up and take any action to prevent it from occurring again, or maybe a parent reported something to the school in writing or notified a school official and no action was taken, that would place the school board on notice or the school district on notice that this conduct is going on in violation of Florida law, and you need to do something about it.
Okay, would you recommend to a parent, I'm sorry to interrupt, would you recommend to a parent then that if, you know, my daughter is getting bullied, I write to the principal on paper and say, I want to put you on notice?
Yes.
How would you handle it?
Well, you would have to do it. You'd have to contact the school officials, put something in writing that where it's documented, and under the Florida statute, they are required to have a protocol in effect to take action and prevent the bullying from occurring, and if they don't, they can lose their funding as a result of that. So it's a state law.
Okay.
Now, the statute does not allow for, or it's silent as to whether or not criminal action can be taken against a person violating the statute.
Okay,
It just provides for disciplinary type conduct.
And as far as you know, there have been no lawsuits filed in Duval County over bullying?
Not that I'm aware of.
Not that you're aware of.
But
go ahead.
Well, you can file there are two types of claims you can file. You can file a state action in state court against the school district based on the school's failure to perform the duty of care and protect the student, but you're limited to $200,000 in that type of case. Most of the cases are being filed in federal court under the Civil Rights Act because there is no cap on damages in federal court.
Okay.
Because it's under the Civil Rights Act. So those are the two type of actions that are being filed.
And I got to bring this up, Eddie, because I know a lot of people out there are going, wait a minute, kids are being bullying and we're going to court over this?
Yeah.
Eddie, I know you make your living off of this,
right.
but justify that.
Well, the statute is clear on that. Kids are going to tease each other. Who hasn't been teased and harassed growing up? I mean,
sure,
it's part of growing up. I mean, it's part of becoming who you are and everything. But under the statute, the conduct must be the point to where you are in reasonable fear of harm to yourself or your property. So the statute defines what bullying is, and it has to place you in reasonable fear of harm to yourself.
Sure. And
if you're not in reasonable fear of harm to yourself, you're not in violation of the statute.
Okay, and I know a lot of parents and a lot of children are tormented out there too, not to minimize the bullying, because certainly some people are really tormented. Eddie, thanks for joining us this morning. Eddie Farah weighing in on bullying and at what point you may want to take it to court.